In my initial days when I used to work on contract, one of the biggest problems that I used to have is having a structural way of contract there in my head. And to overcome this, what I used to do is I used to Google search, internet search, and find a template. But I realized that this way of working on a contract has its own problem. First, this template might not be applicable to the laws that is there in your country. Then this template might not be exhaustive. It might not have some crucial clauses included in that. And then you will get your anxiety attacks later on that, oh my god, have I missed some crucial clauses? Then the template also have this problem that it might not serve the industry that you are making contract for. For this you have to learn the laws of that particular industry in the first place. Now I realized that the best way to do this, to make a contract and to overcome this problem, is not finding a template. I mean, you can find a template and get a very brief idea how to go about the contract, but you cannot completely rely on that. So now what is the solution to this? The solution to this is making a checklist. That is the best way possible. In your initial days, if you've just started making contract, you can have a ready checklist on a piece of paper with you. Now with this, the best thing that will happen is now you know what are the clauses that has to be there in your contract, and accordingly what you'll do, you will accordingly fit in as per the requirement of your client and as per the industry that you are dealing in. Now I have this checklist that I use in most of my contracts, in 99% of my contracts, according to the needs and requirements of my client. I'll read it out for you so that you can jot it down somewhere and have this checklist ready with you. Later on, you'll of course have these things in your head. After you've made dozens and dozens of contracts, you will have automatically these things in your head. Now, to start with the checklist, the first and foremost thing that has to be there is the title. Now, what is the title? Title is what kind of agreement or the contract it is, whether it is, leave-in license, whether it is some kind of a service agreement, what kind of agreement or what kind of contract it is. The second thing that has to be there is the preamble. Now, what is preamble? Preamble is explaining what this whole contract is all about. What's the purpose of the contract? Then the third one is the definitions. Here you are going to define all the crucial terms in a proper way, because in contract it will only mean as per the definition which is there in your definition clause. So you have to be very, very diligent in this. Then the fourth one is the effective date, since when your contract is going to become active, the commencement of the contract. Then the fifth one is the obligations of the parties or the consideration. What are the obligations of the parties? What will be the remuneration? What will be the license fee, etc. has to be there in this. Then the term, that is for how many months or year this contract or this agreement is going to be valid. Okay, so that will be there in the term. Then the termination. What will be there in termination? In termination, you are going to mention the circumstances on the basis of which this particular contract might get terminated by either of the parties or by both the parties. Then there has to be clause of covenants and duties of each party. There has to be a clause of representation and warranties, that is what will be the thing that is going to trigger the right to seek the compensation, has to be there in representation and warranties. Along with that, there are other things as well. Indemnification, on what grounds and to what extent any of the parties is going to indemnify the other party. So these are the 10 clauses that I have mentioned. Now the 11th is the method of payment. Very important, whether you are going to pay in bank, in the mode of bank transfer or by the way of check. Now these are very little things that people miss out, but it's very important to mention in any contract. Then we have the governing law. What are the jurisdictions, in which jurisdiction this law, as per which jurisdiction, what jurisdiction this particular contract is going to be governed by. Then the dispute resolution, very, very, very important clause. Here the arbitration, mediation, conciliation will be mentioned, that how the arbitration will take place, in what jurisdiction the arbitration will take place, how and what kind of arbitrator or who will be the arbitrator appointed. Then we have a clause of waiver. This is the 14th clause. Then we have a clause of non-compete and non-solicit. Now here you are going to mention that you are not, either of the parties are not going to directly compete or work with their competitors and not engage any of the employees or consultant to work with them. So this is equally important. Then we have the clause of assignment. We have a clause of confidentiality, very important clause, the confidentiality. We have another clause of severability. Then if intellectual property is also involved in your work, then you also put in a clause of intellectual property. Amendment, a very little clause but very important clause. If in case this contract is going to be amended, how this contract is going to be amended has to be there in the clause of the amendment. Then breach consequences and breach of remedies. In case of event of default, what will be the consequences and what will be the remedies has to be there. Then there's a clause of entire agreement. Then there's a clause of notices, that in case any of the parties has to give notice, what is a specific procedure by which the parties are going to give notice to the other party. Then there's a clause of jurisdiction. What will be the jurisdiction? Which state has to have the jurisdiction in case you have to deal with any kind of breach or you have to deal with any kind of dispute. Then there's a clause of liquidated damages or limitation of the liabilities. Force majeure is the 26th clause that I've written in my checklist. Force majeure is a very important clause for the cases where something has happened which is beyond the control of either of the parties. Then in that case, like act of God, let's suppose there's a flood or earthquake, then in that case, what are the liabilities, what the parties are going to do. Then there's a clause of exclusivity, and then there's a clause of signature line, which is the 28th point, which is wherein you will put in your signature, both the parties will put in their signature and also the signature of the witnesses. Now, if you have this checklist in your hand ready, the last thing that you have to do is you have to understand the laws of the industry that you're working for. Like, let's suppose if you're working for a pharmaceutical industry, your client is dealing in pharmaceuticals, then you have to learn and read the law of pharmaceuticals, whatever the laws of that particular industry is, and accordingly you have to understand the requirement of your clients and then put in the details in these clauses. And this is the way that you can make your contract a watertight contract. This is the way that you make the best contract ever.